prelude to history making and wait till the Commission submits its findings. But I can vouchsafe this is history in the making. And Prime Minister, as first amongst the equals, is honoring an electoral pledge which features prominently in government's program. And the setting up of a constitutional review commission is fundamental to the process of democracy. The commission will listen to the voice of the people, and it's people legislation first and foremost. Government will pay heed. I'm not saying that nothing is agreed until everything is agreed, but there will be wide consensus. Talk to people who are well-versed in interpreting our Constitution. And like a layperson who moves around with the public, rubs shoulders with one and all, I was told that the Constitution is sacrosanct and supreme, precisely because of supremacy and sacrosanctity of our Constitution, that the Review Commission will not be insensitive to the creation of a Court of Appeal whose judges have to be not only independent, but fiercely independent. How will the judges be selected? The Commission will not make the deliberate choice. It will be the choice of the mere mortals and the expert. The proposal made by a former international judge with the UN cannot and should not go unnoticed. We should always have judges at the Berlin Wall. Madam Speaker, between our government and the previous government, the MSM-led regime, there's not only a vast difference, but there's a monumental difference. The MSM-led regime had a reputation to tamper with the Constitution. The MSM in government was a regime of colorable device. And what did the MSM-led government, why did they convene an early sitting of Parliament on the 26th of January 1993? The political arm of the executive of a decadent regime in collusion with the then Speaker wanted to declare the seat of the then leader of the opposition vacant. The court reaffirmed under Section 37(1) of the Constitution, the Supreme Court, not the Speaker or Parliament itself, has exclusive jurisdiction to determine whether a member of Parliament has vacated his or her seat. The Supreme Court ruled Dr. Lamid Ramgoolam was then allowed to retain his seat. The MSM-led regime in government was a square peg in a round hole. From 2019 to 2024, separation of power was blurred, and collusion between the Speaker and the leader of the House was a trademark of the culture of impunity. Against this backdrop, Madam Speaker, I'll walk you down memory lane to highlight the merits of this bill. And I seek the indulgence of this House, of this honorable House, to step back, not by years, but by generations. Because what we debate today is not simply a piece of legislation. It is a question of who we are as a people, as a nation, what we have built, and whether we have the courage to build something that lasts. In 1961, one of the world's most famous economists, a Nobel laureate, Professor James Mead of Cambridge University, looked at this island and pronounced it doomed. His conclusion was as bleak as it was authoritative. And I quote, "Whatever economic progress Mauritius might achieve would be at least modest." And 11 years later, the Nobel laureate V.S. Naipaul came here and published his verdict. He described Mauritius as an crowded barracoon, a land without destiny. Labour Party, under the able leadership of the father of the nation, proved them to be wrong. Manmohan Singh, then professor, if I'm not mistaken, at Cambridge University, had faith in the leadership of Sir Sivasagar Ramgoolam and the will of our people. So Sivasagar Ramgoolam and other political leaders of the time gifted Mauritius with a constitution written by a legal team led by Professor D. Smith. The latter specifically requested that his ashes be scattered across Mauritius. It was indeed honored. Meade, Tisworth, and V.S. Naipaul were wrong because they looked at our geography and saw only its limitation. They counted our resources and found them wanting. They could not see the one resource that would define this nation and carry it forward. At the end of an arduous road, after years of trials, tribulation, trouble, the new Mauritius was born to be guided by a constitution, the rule of law and separation of power. We receive foreign investment because the world trusts our institutions. We punch above our weight in every international forum because countries know that when Mauritius makes a commitment, it keeps it. Madam Speaker, that is the dividend of democracy. And at the center of that democracy stands a constitution. And the Judicial Committee of the Privy Council in the landmark case of Matadine versus Pointu spelled it out forcefully. And I quote, "A constitution is an attempt at a particular moment in history to lay down an enduring scheme of government in accordance with certain moral and political values." Our Constitution has served us well. The independence of the judiciary, the separation of powers, the system of check and balances, these were not gifts. They were choices made by the freedom fighters of our great little country. Choices that subsequent generations have had to honor and defend. But constitutions, like democracies, do not maintain themselves. They require vigilance, they require reform, and sometimes, as we know only too well from recent memory, they require rescue. Madam Speaker, I will not pretend that the road that brought us here was a straight one. We know what this country went through during the MSM years, an erosion of independence of institutions that generation had built and trusted. There had been an attempt to arrest the DPP, which was unheard of. Our beloved Mauritius descended into a gray zone of electoral autocracy. The people of Mauritius will remember the word planting, once a proud agricultural term in Mauritius, born from the soil, became synonymous with something dark, that the deliberate planting of drugs to destroy lives and silent dissent. This is what we had become. Some police officers whom we trusted for our security had turned into dacoits. Reward money was weaponized to suit the political agenda of the government of the day. So much drug had infiltrated the arteries of this country that we are today seeing the devastating consequences affecting our youth. There was overt surveillance into the private lives of ordinary citizens and members of the press. Phone tapping was rampant. The people of Mauritius gave the answer on the election day. They gave not a mandate, but a verdict. Politics is not a test of popularity, but the will to make hard decisions for the betterment of a nation. Some may argue we govern in poetry, we campaign in poetry and govern in prose. And from the moment this government took office, certain words began quietly to disappear from our national vocabulary. Wiretapping, planting, censorship. In the place came something we had almost forgotten the taste of a free press, independent journalism, the ability to speak, to criticize, to hold power to account without fear. We did not just win an election, we reclaimed a republic, Madam Speaker. But reclaiming what was lost is not enough. Our obligation to this country is not merely to restore, it is to build something stronger in its place, something that makes it harder, not merely unlikely for the abusers of the last decade to recur. Madam Speaker, trust in politics is not maintained by rhetoric. It is maintained by action. When we stood before the President on the 24th of January 2025 and presented the government program for 2025 to 2029, we made a specific public commitment to appoint a constitutional review commission. The bill before this House today is the fulfillment of that commitment to the letter. We said we would do it, we are doing it. The Constitutional Review Commission will be tasked with examining the full spectrum of a constitutional framework and making recommendations for reform. Its mandate is deliberately broad because the task before us is genuinely ambitious. For the first time, a senior officials appointment committee will be established to ensure that the heads of our major public institutions are appointed on merit and independence, not on political loyalty. Fundamental rights will be strengthened and modernized, not only the civil and political rights of the previous century, but the right to a clean environment, to access to healthcare and education, to protection of personal data and privacy in the digital age, rights that Mauritius had already recognized in international treaties it has signed and must now be enshrined in its own supreme law. The independence of the Director of Public Prosecution will be reinforced so that decision to prosecute is never again susceptible to political interference. I'm not saying that the DPP is next to God, but the office has a moral and legal right to justify its decision as and when required. Stronger safeguards will be put around our electoral process, free and fair elections, the independence of the Electoral Commissioner, fast access to justice in electoral dispute, the transparency of political funding, because an election that cannot be trusted is no election at all. And I say it because an election that cannot be trusted is no election at all. Anti-defection provisions will be introduced so that the mandate given by the people to their elected representatives cannot be treated or surrendered for personal advantage. Should an electoral college be widened to give additional powers to the President? It is in our electoral program. It was spelled out in the presidential address. It will be raised and discussed at the bar of public opinion. It is sad that politicians from specific quarters are trying to whip basic and baseless arguments over it. And for the first time, the Constitution will enshrine a principle of freedom of information. Because in a democracy, transparency is not a favor the government grants to the public. It is an obligation the government owes to the people it serves. There have been criticism from the opposition that the mandate of the Commission would be incomplete without the revision of the electoral system, including the best loser system. But the modernization of an electoral system has always been under the aegis of Prime Minister. Several reports have been published, and the work is ongoing. There's a need to avoid unintended consequences. The Commission will act diligently to make the difference without exercising any influence on those who will freely express themselves. But perhaps the most important aspect of this bill, Madam Speaker, is not what the Commission will examine. It's not what the Commission will examine. It is how it will examine. The bill sets out a four-stage consultative process: citizen, civil society, organizations, political parties, and experts will all be invited to submit their proposal. The Commission will consult, it will research, it will deliberate, and then, and only then, will it draft. This is not a technocratic approach of a government that has already decided and is merely seeking validation. It is an invitation to the people of Mauritius to participate in the making of their own constitution. It has been done before. Iceland invited its citizens to crowdsource a constitution in 2011. South Africa built its first apartheid constitution from months of public hearings that reached to every township and province. The legitimacy of a constitution is inseparable from the process that created it. We are asking every Mauritian, what kind of country do you want to live in? What values do you want your supreme law to protect? What abuses do you never want to see again? The Constitution will have together the voices of the people, including the marginalized one. The Commission will be a bridge between government and the people. Madam Speaker, I want to close with a reflection that goes beyond the clauses and schedules of this bill. There is a realignment in our political circumstances today. For the first time in a generation, the government holds constitutional majority required to amend the supreme law of this land. And we must pay tribute to the leaders of all four parties which form this great alliance: Nouveau Démocrate, Résistance et Alternative, MMM, and the Labour Party. That majority was not given to us as a privilege. It was given to us, Madam Speaker, as a responsibility. And this window will not remain open indefinitely. We have before us an opportunity to build a constitution worthy of our history and strong enough to protect our future. The majority is there. The moment is here. And the only question that remains is whether we will have the political will to use it. And I say, yes, we shall. Thank you very much.
Thank you. Yes. Honourable Minister of Environment.
Merci, Madame la Présidente. Je ne veux pas être long. Je pense que ça a été dit par mes collègues. Madame la Présidente, je ne pouvais ne pas intervenir sur ce projet de loi. Comme l'a si bien dit l'honorable Soubon, quelques années encore, nous sommes en train de tracer l'île Maurice de demain, la République de demain. Madame la Présidente, les élections générales de 2024 n'ont pas été des simples élections de remplacement d'une équipe par une autre. Il s'agissait, Madame la Présidente, pour le pays de marquer au fer rouge un gouvernement son temps pour ses innombrables atteintes à la liberté. De marquer au fer rouge, j'ai bien dit, ses abus contre l'État de droit et le pillage systématique des biens publics. Ces élections, Madame la Présidente, ont permis non seulement de sanctionner, comme il se doit, un gouvernement pourri jusqu'à la moelle, mais surtout à travers un score sans appel. En plébiscitant ce gouvernement, la population s'est donné l'espace, la fraîcheur et les moyens pour que les institutions progressent et que le pays renaisse de ses cendres, pour enfin effectuer un grand bond en avant. Ce gouvernement, issu des élections de 2024, représente donc une formidable énergie constructive et une opportunité pour effectuer les grandes réformes nécessaires et depuis longtemps en souffrance. C'est cela l'un des plus grands atouts de ce gouvernement. C'est donc avec cette conviction que ce gouvernement a l'immense responsabilité de concrétiser certains vœux restés pieux depuis longtemps. Le Constitutional Review Commission Bill présenté par le chef du gouvernement l'honorable Premier ministre, Dr Amboulam, en est un exemple concret. Pendant les lustres qu'on a évoqués ici et là, les changements devenus nécessaires pour remettre nos institutions au diapason avec les nouvelles normes de transparence et de gouvernance. C'est donc dans un environnement nouveau, dans un paysage politique plus serein, que nous lançons sur ce chantier constitutionnel. C'est donc dans un environnement sain, je l'aurais dit, que nous sommes en train de venir avec ce projet de loi. Déjà, Madame la Présidente, dès les premiers mois au gouvernement, nous avons lancé des signaux tangibles. Personne ne peut remettre en question le fait qu'avec ce gouvernement, les Mauriciens ont retrouvé leur voix, leur liberté d'expression et une tranquillité d'esprit. Ils peuvent maintenant s'exprimer plus librement, sans vivre sous la menace de l'intimidation. Nous avons vécu ces moments tristes, de l'arbitraire, de planting ou d'atteinte injustifiée à leur vie privée à travers les écoutes téléphoniques. Il ne faut aussi jamais oublier que c'est sous ce gouvernement, c'est notre gouvernement, que l'indépendance et les pouvoirs du directeur des poursuites publiques ont été rétablis et constitutionnellement renforcés. Alors que nous savons à quel point, il faut le redire, plusieurs de mes collègues l'ont dit, le bureau du DPP avait été méthodiquement pris pour cible. Des attaques multiples frontales et démotiver le personnel de ce bureau. D'abord à travers une première tentative de vider cette autorité suprême en matière de poursuite à travers le Public Prosecution Commission Bill, avorté in extremis. Je dois le dire, il faut rendre hommage à l'époque au PMSD à Xavier Duval. Ensuite, la mise sous tutelle du bureau du DPP, sous l'autorité de l'Attorney General, compromettant directement son indépendance opérationnelle et financière. À cela s'ajoutait de bras de fer institutionnels répétés avec l'ancien commissaire de police, des pressions, des commentaires publics et communiqués délibérément destinés à saper l'autorité et le moral du DPP, sans oublier des menaces à peine voilées. Tout comme une atteinte directe au pouvoir constitutionnel du DPP à travers le Financial Crime Commission Act de 2024, qui visait à détourner, à hijack des attributions qui appartiennent constitutionnellement, exclusivement au DPP. Pourtant, Madame la Présidente, malgré ces pressions, le bureau du DPP est resté un rempart contre les abus. Ses représentants ont fait preuve d'un courage exemplaire, notamment lors de l'affaire Kisten devant le tribunal de Moka. Ce gouvernement a donc eu à cœur de restituer à cette institution sa pleine indépendance financière, opérationnelle et constitutionnelle. Pas que ça, nous avons aussi rendu public le rapport du Fact-Finding Committee sur la mort de 12 patients dialysés au New Suyak Hospital durant la pandémie Covid-19. 12 vies, Madame la Présidente, 12 familles brisées. Tout comme nous avons rendu public le rapport de la Court of Investigation sur l'échouement du MV Wakwasho et ainsi que celui sur le Land Drainage Master Plan. Madame la Présidente, on est appelé à faire des choix stratégiques par rapport à notre économie, par rapport à la gestion du social, de l'environnement, pour construire une société durable, une économie prospère et un cadre de vie agréable à notre population. Déjà depuis le début de ce mandat, le scénario business as usual n'est pas une option envisageable. Après le bilan catastrophique laissé par le MSM et amplifié maintenant par la crise et les incertitudes financières internationales. Dans de telles situations, le gouvernement a préféré jouer la corde de la transparence sur la situation exacte du pays et les défis auxquels nous devons tous ensemble faire face dans les mois à venir. Le rapport The State of Economy nous a confirmé comment les institutions financières de l'État fonctionnaient et les conséquences désastreuses pour le pays. Madame la Présidente, ce gouvernement a été élu pour apporter des changements importants, des changements structurels, des changements qui touchent le cœur même de notre démocratie. Mon collègue, le ministre des Administrations régionales, a également lancé des consultations pour une refonte de la Local Government Act. Tout cela indique que le gouvernement veut impliquer la population dans la prise des décisions. Cette réforme de nos collectivités locales comprend aussi l'introduction de la Constitution, des dispositions rendant obligatoire la tenue des élections des collectivités locales à des échéances prévues par la loi. Cela fera partie des attributions de cette commission de réforme constitutionnelle. Madame la Présidente, notre Constitution est un héritage précieux, mais comme tout édifice, elle porte les marques du temps. Des manquements se sont relevés. Il serait irresponsable de les ignorer au nom d'une tradition figée. Notre devoir est de corriger ce qui doit l'être, tout en préservant ce qui fait notre force. Ce projet de loi, une fois adopté, donnera force de loi à la commission de révision constitutionnelle. Il habilite le président de la République à nommer cette commission, dont la mission sera d'examiner et de formuler des recommandations sur les réformes constitutionnelles fondamentales, la protection des droits fondamentaux et la consolidation de notre démocratie et de notre institution, et de nos institutions. Parlons de la composition de cette commission, qui témoigne de l'importance que le gouvernement accorde à ce projet. Une commission présidée par un ancien chef-juge et incluant des personnalités de calibre, un ancien directeur des poursuites publiques, entre autres personnes crédibles dont l'intégrité et l'expérience sont reconnues de tous. Ce gouvernement réunit cette intelligence collective quand ce projet est trop important pour être laissé à l'improvisation. Il mérite le meilleur. Et nous avons mis le meilleur à son service. Madame la Présidente, quels sont les grands actes que la Commission sera appelée à examiner? Premièrement, la création, mes collègues l'ont dit, je le redis, la création d'un Senior Official Appointment Committee, un comité chargé de faire des recommandations au gouvernement sur la nomination des responsables des grandes institutions publiques. Trop longtemps, ces nominations ont été perçues comme des décisions opaques. Ce comité apportera transparence et mérite. Deuxièmement, la création d'une nouvelle cour d'appel au sein de la Cour suprême, composée de juges d'appel. Cela permettra de traiter des appels contre les décisions des juges de première instance, tout en maintenant le droit de recours final au Judicial Committee du Privy Council. C'est une réforme de modernisation judiciaire attendue depuis longtemps. Troisièmement, l'établissement d'une division constitutionnelle de la Cour suprême dédiée au traitement rapide des affaires constitutionnelles et de droits de l'homme, parce que justice delayed is justice denied, surtout quand il s'agit des libertés fondamentales. Quatrièmement, pour avoir dirigé à un moment un journal, j'ai personnellement fait l'expérience de ce que signifie concrètement l'absence de droit à l'information. L'information n'est pas un privilège accordé à la presse. C'est un droit appartenant au peuple que la presse exerce en son nom. La consécration du principe de liberté d'information que la commission de la réforme constitutionnelle sera appelée à examiner vient précisément corriger cette lacune. Madame la Présidente, permettez-moi d'insister sur un point que me tient particulièrement à cœur, la révision du chapitre 2 de notre Constitution. La Commission sera chargée d'examiner comment mieux protéger les droits fondamentaux, y compris ce qu'on appelle les droits de nouvelle génération. Des droits liés à l'environnement, à la technologie, à la santé, à l'éducation, des droits économiques, sociaux et culturels reconnus par les traités internationaux. L'inclusivité ne doit pas rester une simple bonne intention qu'on remet de temps en temps dans des formules ronflantes, mais doit être une réalité au quotidien, peu importe le lieu de résidence d'une personne ou de sa situation de handicap. No stone should be left unturned, y compris contre les discriminations dont sont victimes les personnes en situation de handicap. Cette commission sera appelée à examiner le renforcement de leur protection, un impératif moral et juridique fondamental, garantissant leur pleine participation à la vie sociale, professionnelle et civique sur un pied d'égalité avec les autres citoyens. Encore, le projet de loi mentionne explicitement les droits de la nature. C'est une vision audacieuse, progressiste, en phase avec les grandes réflexions internationales sur notre rapport à la planète. D'ailleurs, à mon ministère, on travaille sur la révision de l'Environment Act et nous avons reçu une 50aine de commentaires du public et de la société civile. Nous allons également examiner comment inscrire dans notre Constitution les valeurs fondamentales que nous proclamons dans notre hymne national. La paix, la justice, la liberté. Ces mots que nous chantons, il est temps de les graver dans notre loi suprême. Le projet de loi, Madame la Présidente, prévoit aussi des dispositions anti-défection pour les membres de l'Assemblée nationale. C'est une mesure de discipline démocratique. Le mandat appartient au peuple, pas aux ambitions individuelles. Madame la Présidente, un mot sur la réforme électorale. Oui, c'est vrai qu'elle n'est pas incluse dans ce projet de loi. C'est un choix délibéré et sage rendu public dans les délibérations du Conseil des ministres du 25 novembre 2025. Il ne faut pas voiler la face. Un système électoral peut faire et défaire un pays. Les enjeux sont différents. Les sensibilités sont différentes. Chacun a son opinion. Chacun a ses appréhensions. Et c'est légitime. Il était donc juste de ne pas tous traiter ensemble, donner à chaque chantier toute l'attention qu'il mérite. La réforme électorale mérite son propre espace, son propre débat. Et je suis sûr que nous aurons cette réponse. Le but de cette démarche est de donner à la population non seulement l'assurance que le processus est sérieux, mais aussi les moyens d'y participer. Madame la Présidente, pour conclure, je veux rappeler pourquoi nous faisons tout cela. Nous le faisons parce que la population de l'île Maurice a exprimé par son vote le désir d'un changement véritable. Nous le faisons parce que la démocratie ne se décrète pas depuis en haut. Elle se construit avec le peuple, pour le peuple et par le peuple. Avec cette commission et ses commissaires mûris par l'expérience, avec la volonté politique claire de ce gouvernement, je suis convaincu que nous allons emmener ce projet à bon port. La confiance que vous nous avez accordée, nous ne prenons pas à la légère. Nous la portons chaque jour comme une obligation. Ce gouvernement s'engage, au cours de ce mandat, à doter le pays d'une fondation démocratique, solide, transparente et surtout capable de résister aux assauts présents et futurs des potentiels fossoyeurs de la démocratie et protéger notre population contre les lois liberticides. Ce gouvernement s'engage à mettre des bouchées doubles pour rattraper un retard dans la mise à jour de nos lois fondamentales, afin de léguer aux prochaines générations un héritage dont elles seront fières. Ce gouvernement a un mandat pour réformer, pour transformer les institutions vitales du pays. Et c'est de loin le bilan le plus pertinent que ce gouvernement s'engage à présenter à la fin de ce mandat. Les travaux de cette commission permettront de garantir le destin démocratique de notre République. Et sur ce, je soutiens pleinement ce projet de loi. Je vous remercie.
Merci. Honourable Member for Rose Hill Stanley.
Madam Speaker, nous discutons du projet de loi qui est devant cette Chambre, le Constitutional Review Commission Bill, dans une grande confusion. En effet, dans le pays et ici même, dans cette Chambre, beaucoup croient qu'en votant le projet de loi qui est devant nous, nous allons apporter des amendements à 19 aspects de notre Constitution, la loi suprême du pays, et traduire ainsi dans les faits telle ou telle mesure du programme électoral de l'Alliance du changement. Or, ce n'est pas du tout le cas. Lorsque nous allons voter le projet de loi qui est devant nous, nous ne ferons que mettre sur pied une commission constitutionnelle qui sera appelée à faire des recommandations d'amendement à notre Constitution. Ces recommandements d'amendement auront à être approuvés ou rejetés ou amendés par le gouvernement. Les recommandations qui seront approuvées par le gouvernement devront alors faire l'objet de projets de loi visant à amender telle ou telle clause de notre Constitution et qui demanderont à être votés à une majorité de 3/4 ou de 2/3 selon le cas de notre Assemblée législative. La première question qui se pose est de savoir combien de temps prendra la commission que nous allons mettre sur pied pour faire ces recommandations au gouvernement. Combien de temps prendra ensuite le gouvernement pour décider quelles recommandations il acceptera ou rejettera ou amendera? Et enfin, après avoir décidé, combien de temps prendra le gouvernement pour venir de l'avant avec des projets de loi amendant tel ou tel aspect de notre Constitution? On peut s'attendre à ce que la Commission constitutionnelle prenne autour de 2 ans pour soumettre ses recommandations. Et on peut s'attendre à ce que le gouvernement actuel prenne autour d'1 an avant d'approuver telle ou telle recommandation de la Commission constitutionnelle et de préparer et soumettre au Parlement différents projets de loi amendant telle ou telle clause de notre Constitution. En d'autres mots, il y a un risque, 1 an et demi déjà depuis les dernières élections générales, qu'aucun amendement ne soit apporté à notre Constitution d'ici les prochaines élections générales. J'espère néanmoins que les choses évolueront différemment. Je passe à la réforme électorale. Le 24 avril dernier, le cabinet a approuvé le Constitutional Review Commission Bill qui est devant nous. Le même jour, le cabinet confirmait que, je cite le cabinet de communiqué du Prime Minister's Office, je cite, "Cabinet has taken note that the issue of electoral reform is being addressed separately." Et c'est pourquoi les terms of reference de la Commission constitutionnelle n'incluent pas la réforme électorale, qui n'est donc pas pas devant la Commission constitutionnelle que nous mettons sur pied. La Commission constitutionnelle, au terme de ces Terms of Reference, sera seulement appelée à traiter de recommandations visant à améliorer le electoral process. Je cite ces termes, les termes utilisés dans les Terms of Reference de la Commission qui est devant nous, que nous mettons sur pied. Donc, je répète, la Commission constitutionnelle sera seulement appelée à traiter des recommandations visant à améliorer le electoral process, c'est-à-dire le déroulement du vote, et à consolider l'indépendance et les pouvoirs de la Commission électorale et du commissaire électoral. La réforme électorale, elle, si elle se fait sous le gouvernement actuel, ce qui est, d'après moi, très improbable, devrait introduire une dose de proportionnelle, éliminer l'obligation pour les candidats de déclarer leur communauté et garantir une présence féminine adéquate au Parlement. Je passe à l'élection du président de la République. Un amendement de dernière minute aux Terms of Reference de la Commission constitutionnelle est devant nous. Un amendement est devant nous, qui propose que le président de la République soit dorénavant élu par un collège électoral et non par le Parlement, comme c'est le cas actuellement. Cet amendement tardif a créé de la confusion. En effet, on ne parle pas ici d'un président élu au suffrage universel, comme en France, mais d'un président élu par un collège électoral, comme en Inde, où le président est élu par le Parlement national, le Lok Sabha, et les parlements régionaux. Ici, ça pourrait être le Parlement et les élus régionaux. Je passe à la création d'un Senior Officials Appointment Committee qui ferait des recommandations au gouvernement concernant la nomination des Heads of Major Public Institutions. Ce n'est pas ce que j'avais proposé au gouvernement. Un Senior Officials Appointment Committee qui ne ferait que des recommandations au gouvernement ne changerait pas grand-chose. Ce que j'avais proposé s'inspirait, mais s'inspirait seulement, ne copierait pas. Mais ce que j'avais proposé s'inspirait de ce qui existe déjà depuis des années aux Seychelles. Et je l'avais expliqué cela. Aux Seychelles, c'est un Constitutional Appointment Authority, pas committee, de 5 membres, le président de la République nommant 2 de ces 5 membres et le leader de l'opposition 2 autres, le 5e étant choisi par consensus pour présider ce Constitutional Appointments Authority, qui lui-même sélectionne toute une série de ceux ou celles appelés à exercer de hautes responsabilités, allant de la commission anticorruption à la commission électorale, en passant par l'auditeur général, le Seychelles Broadcasting Corporation, etc. Je termine, Madame Speaker, en demandant au gouvernement de prendre l'engagement, ici et maintenant, de rendre public le rapport et les recommandations de la Commission constitutionnelle que nous mettons sur pied. Je vous remercie.
Yes, Honorable Attorney General.
Madam Speaker, as the Chief Legal Advisor of the Government, it is not my role to make the case for this bill from a political angle. The Honourable Prime Minister made that case in opening this debate, and he will complete it this evening. This House is entitled to expect the Principal Legal Advisor of Government to answer as questions of law the objections, remarks, comments that have been put forward from the other side. Let me say at the outset that I thank the Honourable Leader of the Opposition and the Whip of the Opposition for putting their objections seriously, albeit, I will argue, erroneously, and the Honourable Members of the Opposition for putting theirs thoughtfully. What I will do is that I will take them on one at a time, and I will do so as a lawyer must do, on the law and nothing but the law. Madam Speaker, allow me to draw the attention of the House to what this bill really is and what it certainly is not. And this has been alluded to by the first member of Stanley Rosil just now. It is not an amendment of the Constitution. Not a single comma, not a single word of our Constitution is being amended tonight. This bill only establishes an independent commission to consult the nation and to take expert advice and to recommend. The report of the proposed amendments will return to this House, and every member will have his or her say and vote thereon. That is how it will be and how it should be. The Honourable Leader of the Opposition opened his critique with a rather bold assertion that the government has acted à l'envers. He used our common expression en bas because he said the choice of the chairperson, vice chairperson and members of the commission preceded the formal enactment of this bill. He invoked in passing, he said, the examples of Kenya and Canada to suggest that law must always precede nomination. With respect, Madam Speaker, that argument, however eloquently presented, is factually incorrect, constitutionally unsound, and contradicted by the very Commonwealth precedents he seeks to rely upon. I explain myself. Let us begin with first principles. This bill does not purport to create the Commission ex nihilo. It provides the legal framework, the powers, the mandate, the process, the immunities, and the independence guarantee under which the Commission will formally operate. The prior designation of a distinguished former Chief Justice and eminent commissioners was a statement of intent and preparedness. It signaled to the nation that the potential appointees, the seriousness and urgency of this constitutional exercise. The bill now gives that intent the force of law. The Honourable Leader of the Opposition cites Kenya. So let us look more carefully at the Kenyan example. When Kenya undertook its constitutional review process leading to their 2010 constitution, the Committee of Experts, the body tasked with reviewing the harmonized draft, was appointed under the Constitution of Kenya Review Act of 2008. However, Madam Speaker, that appointment process was itself preceded by extensive governmental consultations, informal identification of candidates, and public discussions about who the expert members would be before the formal gazetting. The sequence was not clean legislation, then clean appointment. It was iterative, practical, and human. Then comes South Africa, a country whose constitutional transition is one of the most celebrated in Commonwealth history. The Constitutional Assembly that drafted the final Constitution of '96 was set up under the interim Constitution of 1993. Yet, crucially, many of the substantive decisions, thematic commissions, and technical committees that shaped the final Constitution were assembled, briefed, and commenced their deliberations during the transitional period, before the final legal architecture was fully in place. No one accused then the ANC government of acting à l'envers. They acted with urgency, they acted with purpose, and they succeeded. Lastly, Canada. It is an even more instructive example. The Citizens' Assembly on Electoral Reform in British Columbia, one of the most celebrated exercises in participatory constitutional deliberation in the Commonwealth, was announced by Premier Gordon Campbell in 2002, with the terms of participation and the commitment to a Citizens' Assembly made public before the Enabling Order in Council was formally gazetted. The selection process was designed and the Secretariat mobilized before the precise legal instrument was finalized. Again, intent, designation, then formal legal authority in that sequence. Lo and behold, Madam Speaker, is it not what we are doing today? This Constitutional Review Committee does not exist until this House wills it into being, and its members are not appointed until this Act is in force, since it is the empowering statute that provides for their appointment. And when the appointments come to be made, they will be made by the President of the Republic. And under Section 64 of our Constitution, the President will act in accordance with the advice of Cabinet or of the Prime Minister, because that is the case here. That is not accidental, Madam Speaker. That is the settled architecture of our Republic. A Cabinet of Ministers that identifies in advance persons of standing whom it intends to recommend does no more than any responsible government does. It prepares to implement the law it asks Parliament to pass. Would the Leader of the Opposition truly have us legislate first and only then begin to wonder who on earth might serve on that commission? A government that plans ahead is not a government with something to conceal. It is a government that means to act the moment this House has spoken. The designation is not the appointment. The appointment is an emanation of this Act, and it will follow this Act in the constitutional form that Section 64 prescribes, no more, no less. So, Madam Speaker, where does that leave the honourable member's argument? It leaves it awash on the shores of legality. Mauritius is not lagging behind Commonwealth practice. Instead, we are exceeding it. This government has chosen to do more, not less. We are not content to convene this commission by a mere resolution or warrant. We are placing it on a statutory footing before this House, its independence guaranteed by Clause 4.2 and its consultative duties written into Clause 7. Madam Speaker, we have given this House and this nation more scrutiny, more transparency, and more protection than any of the precedents the honourable member admires. He cannot praise those models in one breath and condemn us in the next for surpassing them. So much for the en balao argument. And let me meet head-on the insinuation lurking behind this criticism that to name the commissioners in advance is to make them creatures of this government. The opposite is true. That argument of his is indeed en balao. It was precisely because certain clauses of this reform touched the most sensitive nerves of the constitutional order, the office of the presidency, the architecture of our justice system, the rights of the citizens against the power of the state, that we sought from the very start persons whose independence is beyond question, and we named them openly months ahead for the whole nation to scrutinize. Openness, transparency, certainty, and institutional independence, the four corners of the rule of law, which I have said time and again we shall uphold, come what may. Madam Speaker, servility conceals its appointments. Independence publishes them. A government bent on capturing a commission does not parade its members in advance and dare the opposition to object. It does its work in the dark, with it the opposite. The early designation is not the fingerprint of political control. It is the proof of transparency. And the caliber of the persons chosen is itself the guarantee of their independence. Madam Speaker, the Honourable Leader of the Opposition also alluded to the fact, so he says, that the government is imposing its own propositions upon the Commission, that we begin the process, as he puts it, backwards. Nothing can be further from what is actually happening. And I will answer him on the law and on the record. Now, these propositions are not imposed. They are the 18 proposals the electoral itself endorsed in November 2024, as the Honourable Third Member for Grand River North West and Portlaoise West reminded the House. And even then, the Commission is still free to range beyond them, for the words inter alia in Section 4 mean exactly what they say. To give a Commission terms of reference is not to start backwards, it is to start properly. A Commission with no direction is not an independent Commission, Madam Speaker. It is merely a Commission adrift. We want clarity and purpose. We want traction on the main subjects. There lies our wish, the wish of the people. Madam Speaker, if I may now turn to the arguments of the Opposition Chief Whip. He listed what he called the flaws of the bill.
Not Chief Whip.
I'm very sorry. Don't get upset. The Whip of the Opposition. Yes. I was mesmerized by you right now.
Oh, yeah.
He listed what he called the flaws of the bill: no quorum, no qualification criteria, no voting mechanism, no independence expressly stated. Let me be blunt, to the point and clear. A statute that establishes a commission of eminent persons, but then attempts to micromanage the quorum, its order of voting, would be a statute that does not trust the very persons it appoints. Quorum and procedure are matters properly left to the Commission's own rules, as they are for commissions the world over. There is no prescribed voting mechanism, because a body of this kind proceeds whenever it can by consensus rather than by division. And independence expressly stated? Well, independence does not live in a recital, Madam Speaker. It lives in the caliber of the members, of which I have already alluded to, and in the statutory function they are given. Let me take the Honourable Member to the text for fear that he may have inadvertently missed it. That provision reads, and I quote, "The Commission shall, in the discharge of its functions and exercise of its powers under this Act, act independently and shall not be subject to the direction or control of any person or authority." Madam Speaker, the Opposition Whip built part of his argument on an old quip, that to bury an issue, you appoint a commission. Let me answer the quip with what the bill provides. Now, you do not bury a reform by carrying it around the country in public sittings, by putting every submission on the record, and set it up by an Act of Parliament. If the powers of this Commission are given by the people, acting by and through its elected members, it is a legal imperative that it must report back to Parliament. Now, he cited the Truth and Justice Commission, whose finding, he said, gathered dust and were not implemented. But the cure for a report that was ignored is not to refuse to commission the report. It is to bind its findings to this chamber, which is exactly what we are doing now today. The Honourable Fourth Member for Portlaoise Mortaillon also found fault with our timing, perhaps overlooking the fact that we brought more than 30 bills to this House last year. He said our government promised reform within 6 months, and we are still here after 18. That simply is not correct. What was promised was a setting up of a commission within 6 months. What is true, however, is that we are late in coming to Parliament with this bill. But we are late, Madam Speaker, precisely because we declined to do this exercise carelessly, because we took the counsel of a former Chief Justice and a former DPP to get the framework right. And let me reassure you, reassure him. He need not lie awake over a commission that never dies, a money pit that outlives its purpose because a body created by statute for a defined task is factus officio the moment it has reported. It is the most temporary of institutions. Its permanence is one thing he need not fear. Madam Speaker, the opposition whip next said that we were wrong to have thrown every reform into one basket, and in doing so, paralyzed those that could move quickly. He would have the statute itself sort out the mature reforms from the complex ones. I understand the instinct, but it is the wrong hen on the knife. Whether a reform is truly ripe for immediate enactment or needs deeper study is a judgment of substance, and it is the very judgment we are appointing these commissioners to make. And speed is not lost. Nothing in this framework forbids the Commission from issuing an interim report on whatever it feels is ready. The stage report referred to by the honourable member is indeed that interim report which framework already is allowed in this bill. Let's take his own prime example, the judiciary. He said the programme promised a superior court of appeal on Lord Mackay's model, yet Section 4K speaks only of a court within the Supreme Court. And that word, he says, betrays the promise. Madam Speaker, it does not. Section 4K is a term of reference. It is not the constitutional text that will create the court. It tells the Commission where to look. It does not pre-write the architecture the Commission will recommend, nor the amendment this House will probably enact. If only a distinct and institutionally separate court will truly secure judicial independence, and there is real force in what Lord Mackay said, then that is the case the opposition whip should make to the Commission. Within the Supreme Court, as far as I can say, means literally that the Court of Appeal will be an extension of the Supreme Court as we have it today, with the Chief Justice remaining the apex authority of the Supreme Court. Madam Speaker, may I now come to the point raised by the Honourable First Member for Vaca-Floreal on electoral reform. Entre autres, la fameuse dose de proportionnel, the representation of women in Parliament, the balance of our constituencies, and the end of the mandatory community declaration. The Honourable Member regrets that none of these is entrusted to the Commission. But I must say with respect that she answers her point in the very breath in which she makes it. For the Honourable Member herself told this House that removing these matters from the text to be treated separately and more swiftly could be a good thing, because our electoral law must not be amended on the eve of a poll, because the subject matter has been the object of so much work in the past that we may move towards the consensus that has emerged without reinventing the wheel. Madam Speaker, I could not have put the government's own reasoning better. That is precisely why electoral reform is not referred to the expert commission. Indeed, one cannot read either the words electoral reform or the words proportional representation in this bill. In fact, on electoral reform, the consultations have already taken place. The public has already been invited to file its representations. So to send a question that has already been consulted upon back to this Commission would not be reform. It would be delay dressed up as diligence. It would expose us to the very danger the Honourable Member warns against, namely, tampering with the rules of the contest, too close to the contest itself. Madam Speaker, electoral reform is a highly strung political matter, and perhaps not fit for the works of the Commission, of the Constitutional Review Commission. That Commission, Madam Speaker, will do the deep, deliberative work that the new generation of rights in our institutional architecture require. Electoral reform, on the other hand, already ripe, will proceed on its own track and arrive before this House in its own right. The Honourable Member need not fear that it has been forgotten. She will have every opportunity to hold the government to it when that bill is laid before the House. Madam Speaker, the Honourable Third Member for Bobassa and Petite Rivière has pressed on his side for more clarity on the Electoral College for the election of the president. So let me outline things after what has been said by the first member from Stanley-Rosehill. An electoral college is no more than a defined body of electoral representatives who together choose the head of state in place of a bare majority of this assembly. I was aghast to hear political commentators, not later than yesterday night, opining on the form it will take, jumping the gun and making ill-advised assertions. Let me make it clear, nothing has been decided yet. We must await the report and the recommendations first and foremost. We have a number of examples around us. India elects its president this way, Germany its federal president, small islands, republics such as Trinidad and Tobago do the same. In each case, the purpose is the one our government program states, to give the president a mandate, not more powers. A mandate from a broader base, so that the first citizen of the republic belongs to the whole nation and not to the party of the day. This does not create an executive presidency. The executive powers remain with cabinet, led by the Prime Minister, answerable to this House. Nothing in this proposal changes that position. The opposition whip, for his part, would have parties simply disclose their nominees for President, Prime Minister and Minister of Finance before polling day. That is an idea worth placing before the Commission. But it is only an argument about which broad base is best, not an argument against having one. As for who sits in that college, by what criteria and how it votes, the very questions the Honourable Third Member for Babassa and Petite Rivière fairly asked, that, Madam Speaker, is precisely what we asked the Commission to settle. We do not ask this House to adopt an electoral college today. We ask only that the Commission examines it with public and expert input and to report. An opposition that believes in checks and balances should welcome that inquiry, not fear it. Madam Speaker, the opposition whip warned that this Commission must not become a shield behind which government hides. But a shield, by definition, is a thing one hides behind. But we are not using a shield. We are asking the country to do the very opposite. We are asking the people to step out and be heard. So let me close not with an argument, but with an invitation to the leader of the opposition, to the whip of the opposition, to the honourable members of the opposition, to all electoral representatives of this House, and to the Mauritian public. I say this: stand up, be counted, speak out, because your voice matters. Bring your suggestions, bring your ideas, bring your objections, lay them before the Commission and watch the Commission weigh them on their merits. The honourable members on this side, Madam Speaker, have answered the politics of this bill. Some have yet to do it. I, for one, have sought to answer the legal angle. And in the law, Madam Speaker, this bill is sound, it is constitutional, and it is the only proper, lawful first step towards the new constitution that this nation aspires to and has asked this government to deliver. This moment, Madam Speaker, is indeed a historical one and an opportunity for every one of us, from all walks of life, who want to take part, to do so, in order that we may leave the legacy of a better constitution for future generations. With these words, Madam Speaker, I commend this bill to the House.
Thank you. Honourable Minister of Housing.
Thank you, Madam Speaker. Before I turn to the substance of this bill, Madam Speaker, I hope, with your permission and the permission of my colleagues on both sides, allow me a personal remark. I cannot rise today to address the House without feeling the weight, very keenly so, of those that came before. 61 years ago at Lancaster House, my late grandfather, Sir Abdul Razak Mohammed, leader of the CAM, in alliance with the Labour Party of Sir Sagar Ramgoolam, sat at the table. At that table, as the foundation of our independence was negotiated. 59 years ago, my late father Yusuf Mohammed was elected to the inaugural Legislative Assembly at the general elections of 1967. Today, in 2026, I find myself standing before this House, embarking upon a review of that very constitution, as a member of the Labour Party led by Dr. Navin Ramgoolam, Prime Minister. I do not say that to claim any inheritance of merit. Madam Speaker, merit in this House is earned and not bequeathed. The work of building a constitutional order is not the work of a single generation. Those who framed it back in the days could not have imagined Mauritius of 2026, and all of us here today will not be able to imagine Mauritius of 2068. Madam Speaker, a bill modest in its length but monumental in ambition. For what we begin today is not the amendment of a clause, nor the fixing of a single provision. What we begin today is the most serious, the most structured, and the most participatory examination of our supreme law. The law of this country we've ever undertaken ever since the 12th of March, 1968. Our Constitution is now 58 years old. It has served us well, but even the finest vessel, after 58 years at sea, must be brought into dry dock, not to be discarded, but examined, repaired, modernized, and made ready for the voyage ahead. The conversation must start now. This is what the bill does, no more and no less. Madam Speaker, our Constitution has been amended on some 24 occasions since independence. Each amendment has its own story, and some must be told honestly today. In 1969, we made the first operational adjustments after independence. In 1970s, we lowered the voting age from 21 to 18, a genuinely democratic act. A young person watching this debate today votes because of that reform. In 1982, Madam Speaker, 1 month after the famous 16-0 of June 82, if I remember correctly, it was the 11th of June, 82. I remember. Act 2 of 1982 was passed through this very House. It amended Section 113, entre autres, of the Constitution. The change appeared technical. The words, I quote, "for such term not being less than 4 years," were replaced by, I quote, "for such term not exceeding 4 years." 5 words, Madam Speaker. 5 words that quietly weaken the security of tenure of the Director of Public Prosecutions if appointed under Section 113. 5 words that weaken the security of tenure of those officials such as the Commissioner of Police, the Director of Audit, the Electoral Commissioner, and every sentinel of our democracy. 5 words that made those guardians of the Republic appointed under Section 113 vulnerable to pressure from whichever government held office. Some have even called it the ratchet effect, the slow cumulative weakening of institutional independence that we have lived with for 44 years. That, Madam Speaker, is how democracy is wounded, not in a single blow, but in 5 carefully chosen words passed in haste while the nation celebrated a landslide. In 1991 and 1992, we became a republic, achieved without a referendum, by the 3/4 consensus in this assembly, providing that when political will exists, great reforms indeed are possible. In 1995, we abolished the death penalty. In 2001, we gave Rodrigues the autonomy it deserved. In 2014, the country attempted a serious electoral reform that died for want of consensus. Many bear scars from that episode. We should not pretend otherwise. The lesson is clear. When we patch in haste, when we weaken. When we reform in consensus, we strengthen. This bill chooses consensus over haste. Some have referred to the need to go faster, but let us, I say again, choose consensus for it to strengthen and for us to succeed. I now turn to the heart of any constitutional debate, the everyday Mauritian in whose name we sit in this chamber. To the student preparing for their exams, this bill is about your future. The Commission will examine a constitutional right to quality education and a freedom of information principle that will let you request the data shaping the decisions affecting your life. To the worker in the textile factory, I say, to the nurse on the night shift, the bus driver, the cane cutter, the call center agent, this bill is about your dignity at work. The Commission will examine enforceable rights to health, social protection and fair conditions. The expanded Public Bodies Appeal Tribunal will mean that when you are passed over for a promotion you earned, you will have a real forum to demand justice, not a closed door. Yes. To every young Mauritian who has applied for a public sector job and felt that connections mattered more than competence, this bill is for you. The Senior Officials Appointment Committee, that is but a reflection of what is happening in the United Kingdom, will ensure that the leadership of our great public institutions is determined by merit, not patronage. The day is coming when fairness in the public sector hiring will not be a hope, it will be a right. Some see everything as being dark. I have to believe that there is light. To the fishermen whose catch is collapsing, the diver who has watched our reefs bleach, the villager fighting a polluter, the young activist defending, for instance, the Black River Gorges, the bill is for you. For the first time in our history, the Commission will examine the rights of nature, combined with public interest litigation and class actions. An ordinary citizen, a small association, a village, could go to court on behalf of the lagoon itself. The era in which our environment has no voice in our courtrooms is coming to an end. I see the smiles of some of my friends. To every citizen who has asked the government a question and received silence, this bill is for you. For decades, under every government, including those I have formed part of, Mauritius has promised a freedom of information and delivered none. The state of affairs stops now. It ends here. And to those who have called for the right to referendums on matters of fundamental national importance, this bill opens that conversation. The people's voice must not only be heard at elections, Madam Speaker, it must be heard on the great constitutional questions of the day. Allow me, Madam Speaker, the Honourable Minister for Agro-Industry and also the Honourable Minister for Social Security and some honourable members did make reference to the best loser system. I believe Honourable Minister for Social Security also made... Well, no, you'd made reference to the issue of community declaration.
That's good.
The word best user system was pronounced by Honourable Minister of Agro-Industry and other members. I'm talking about those who spoke today. Madam Speaker, I come now, and because of that, I shall refer with reference to clause 4A and 4R of the bill. I come now with the greatest care and respect to a matter on which this chamber has been quiet for a long time. I come to it not to accuse, not to assign blame, not to reopen old wounds. I come to it because a serious constitutional review cannot in good conscience set it aside. And because it is better, surely, that we raise it ourselves in this chamber with the dignity it deserves. than that it be raised for us by others in less hospitable forums. I'm referring, Madam Speaker, to the figures from 1972,
Yes.
on which parts of our electoral architecture and process it continues to rest. The Honourable Minister of Social Security made reference to the United Nations, to the Privy Council. Those were issues that were also referred to in the pronouncements. I do not propose this afternoon to pronounce on what should be done. Far from it. I propose only to ask questions. Questions which I believe every honourable member on every bench of this House must privately have asked themselves at one time or another. Questions which the Commission, in the course of its work, will be far better placed than this chamber to answer. May I, Madam Speaker, ask, is it sustainable in the 21st century for the demographic basis of any part of our constitutional order to rest on figures collected back in 1972? What does it say to the international community? To those friends of Mauritius who, in July 2012, in the case of Naren and others, expressed concern under Article 25 of the International Covenant on the Civil and Political Rights, that 14 years have passed without our having taken up that conversation in earnest. If we cannot have this discussion now in the context of the most comprehensive constitutional review since 1968, with a commission of experts, with public consultation built into every stage, with the protection of the three-quarters majority, then when, Madam Speaker, can we ever have it? I do not pretend that these are easy questions. I know they touch on matters about which sincere people, including dear friends across this chamber, hold deep and differing views. Views formed by our particular history, by the memory of difficult times, by a profound love of country and fear of disturbing what holds us together. I respect those views. I share many of those instincts myself. But I would put a question further to the House. Is it possible that the path of postponement, of leaving those matters perpetually for another day, another government, another generation, is itself a path with costs we have not properly counted? Costs that fall on us, not in this chamber, but on the ordinary citizen in whose name we sit. That, Madam Speaker, is a question I believe the Commission is uniquely well placed to consider. Madame la Présidente, permettez-moi sur cette question de m'adresser à la Chambre dans notre autre langage de travail, car ce que je vais dire touche à un principe d'équité qui dépasse toute langue et toute communauté. Ce projet de loi propose de renforcer la protection contre la discrimination. L'article 16 de notre Constitution protège déjà chaque Mauricien contre la discrimination. Nous avons ratifié des instruments internationaux qui nous obligent à surveiller et à signaler la discrimination dans notre société. Mais je voudrais poser avec respect une question à cette Chambre. Comment évalue-t-on dans la pratique le respect de ce droit fondamental? Un citoyen qui soupçonne d'avoir été désavantagé peut présenter son cas individuel. Mais peut-il, dans l'état actuel des choses, démontrer un schéma structurel? Une famille qui estime que son quartier est mal desservi par l'investissement public, peut-elle le prouver autrement que par l'anecdote? Un jeune diplômé qui se sent exclu des opportunités, peut-il appuyer son sentiment sur des données officielles? Tous ces Mauriciens jouissent d'un droit constitutionnel contre la discrimination. Aucun d'entre eux ne dispose pleinement des outils probatoires nécessaires pour le faire valoir. Et c'est là, Madame la Présidente, le paradoxe que ce projet de loi met en lumière. Un pays peut-il en toute cohérence prétendre combattre une chose qu'il refuse de mesurer? Un droit qui ne peut être vérifié empiriquement n'est-il pas un droit exercé dans l'obscurité? Et les premières victimes de cette obscurité ne sont-elles pas justement les citoyens ordinaires qui n'ont pas, eux, d'autres moyens que de faire entendre leur voix? Je pose ces questions, Madame la Présidente, en toute humilité. Je ne prétends pas y avoir les réponses définitives, mais je crois que ce sont des questions que la Commission ne peut pas, en toute conscience, écarter. Madame la Présidente, nous ne sommes pas seuls à devoir penser ces questions. D'autres démocraties pluralistes dans les contextes parfois plus délicats que la nôtre, ont eu à se les poser. Examinons brièvement et avec humilité ce qu'elles ont fait. Singapour, une société profondément plurielle comme la nôtre, collecte des données démographiques détaillées dans chacun de ses recensements. Elle s'en sert pour concevoir sa politique de logement, sa politique éducative et son système de représentation. Singapour est aujourd'hui l'une des sociétés plurielles les plus cohésives du monde. La collecte des données n'y a pas divisé la nation. Au contraire, elle a permis à l'État de démontrer, chiffres à l'appui, qu'il prend au sérieux l'expérience de chaque communauté. Le Canada, de même, le Royaume-Uni, utilise le ethnic monitoring dans l'emploi, la santé et la police. C'est précisément cette pratique qui a permis à la suite de l'enquête Stephen Lawrence et du rapport Macpherson pour identifier le racisme institutionnel dans la police britannique et de déclencher les réformes qui ont suivi. Sans ces données, ces réformes auraient été impossibles. La transparence, Madame la Présidente, n'a pas affaibli l'unité britannique, elle l'a rendue plus honnête. Je ne propose pas que Maurice copie l'un ou l'autre de ces modèles. Chaque démocratie doit trouver sa propre voie, adaptée à son histoire, à sa sensibilité, à sa réalité. Mais permettez-moi, Madame la Présidente, de poser cette question. Si toutes ces démocraties pluralistes ont jugé que la mesure était compatible avec et même nécessaire à la cohésion nationale, sur quelle base soutenons-nous à Maurice que le silence statistique servirait mieux à notre unité? C'est une question, encore une fois, que je laisse à la Commission le soin d'examiner, avec sérieux, avec respect et avec la sagesse de tirer les leçons utiles de l'expérience internationale, tout en demeurant fidèle à notre identité mauricienne. Madam Speaker, I am not this afternoon proposing any particular outcome. I am proposing only that the Commission be given the political space, which it has, and the political invitation from this chamber to examine those matters with the seriousness they deserve. Should it find a path forward, and an appropriate one, that path could rest on principles that any member of this House or on either side could reasonably support. A path that is voluntary, not compulsory, where citizens choose whether and how to identify, including the option to identify simply as Mauritian. A path that is strictly purpose limited, used for measuring fairness and designing policy, better policy. Never, I underline that, never for electoral profiling, never for political mobilization, never for surveillance. A path that reports only in aggregated form, illuminating patterns, never exposing individuals. A path, and I underline that as well, that decouples any such measurement from our electoral mechanisms, separating the legitimate questions of equity from the contested questions of representation. And a path independently overseen by a statutory body insulated from political interference and accountable to this Parliament. Let me be clear what this bill is not. This bill does not amend the Constitution. Not a single comma is changed. The Commission only recommends, and has been expatiated upon before me, every proposed amendment must come back to this chamber. Every single one must command the required majority the Constitution rightly demands. Nothing becomes law without the consent of this Assembly. This bill is a constitutional invitation to govern on those matters as a nation rather than as fractions. I extend that invitation today in good faith and in the hope that on questions of this gravity we may yet rise above the everyday battles of this chamber. In 50 years' time, historians will not remember the procedural skirmishes of any given session. They will remember whether in 2026 this Parliament had the courage to renew the foundation of the nation. They will ask whether we repaired what was broken. They will ask whether we had the wisdom and the gentleness to take up the questions that has remained too long unasked. They will ask whether we understood that the unity worth preserving is not the unity of silence, but the unity of demonstrable fairness, the unity of a republic that trusts its citizens with the truth about itself. I do not want to be amongst one of those who fail to seize this moment I pray that this assembly is not an assembly that lets it pass. This bill is our chance, a chance, and we should seize it. I commend this bill to this honourable House. May God bless the Republic of Mauritius.
Yes, Honourable Deputy Prime Minister.
Madam Speaker, I won't be long. The Constitutional Review Commission Bill before us is not simply another item on our legislative agenda. It is a significant milestone for the evolution of our democracy. We have the duty today to do more than just make law. We are doing what we promised to the citizens of this country on the 10th of November 2024. We promised to legally address the violations of our rights as citizens, which we endured during a decade. While commending the bill, the Prime Minister clearly set out the scope of this proposed legislation, i.e., the setting up of a commission to review the Constitution. Madame Speaker, une constitution qui a fonctionné dans le passé l'était dans un contexte particulier. Nos leaders qui nous ont gouvernés dans le passé, les tribuns, ont respecté la Constitution et les différentes conventions de notre vie démocratique. Mais quand l'État est entre les mains de ceux qui n'ont aucune intégrité ou qui ignorent volontairement ou involontairement les conventions, cela crée des dommages profonds à la nation. Nous en avons fait l'expérience dans le passé. Et c'est précisément la raison que nous nous devons de faire empêcher qu'aucun autre gouvernement ne slide into the kind of creeping authoritarianism this country endured between 2014 and 2024. Je me réfère ici aux dérives parlementaires du passé. Ce n'était pas seulement des attaques contre une institution, mais surtout une atteinte on the very forum of democratic accountability. Suspension, les voix des élus étouffées, suspension, not for a day, Madam Speaker, not for a sitting, but for the remaining session. The voice of the electorate was deliberately silenced. Today, this is no longer the case. Thank you for that, Madam Speaker. This said, allow me to move to another issue. Madam Speaker, every time the MMM has been in government, it has used that position to consolidate the country's democratic system in terms of permanent and tangible reforms. The MMM has never played a decorative role in government, and we have no intention of playing that role today. The amendment that made the postponement of general elections constitutionally impossible is our doing. Today, I wonder what the MSM would have done had we not amended the Constitution for mandatory elections on due date. However, we should have extended the amendment to local government elections. Madam Speaker, on the electoral reform, the MSM was dead against. On ne pouvait pas dire Tout va très bien, Madame la Marquise. It cannot be said that all was rosy in 2000-2005. Le gouvernement de 2000-2005 a raté une occasion en or de concrétiser la réforme électorale. Had we completed the reform, then much of the recul démocratique of the last decade could have been avoided. Si cela avait été fait, nous aurions évité la pagaille qui a fait reculer notre pays entre 2014 et 2024. L'histoire retiendra cet énorme gâchis. Madam Speaker, the MMM has been campaigning for electoral reform since 1986. A first document, a fair and workable electoral system, was published. Because we understood since then that there is no real democracy if Parliament does not reflect the will of the electorate. Because the question was never about what suited or suits the MMM. The question was, and still is, about what best serves the country. And the objective is the same today. However, Madam Speaker, this is not the issue today, as the electoral reform will be taken up separately as decided by the government some time back. Madam Speaker, with regard to the possible introduction of an electoral college for the election of the President of the Republic, the question is, what kind of society do we want to leave as legacy to our future generations? In a society as diverse and plural as ours, it is important that the process leading to the election, the choice of our head of state, inspires confidence across all sections of the population. Exploring an electoral college mechanism could encourage broader consensus, greater political maturity, and a more balanced approach to national leadership. This is about reinforcing trust in our democratic institutions and ensuring that the presidency continues to embody the dignity, neutrality, and unity of the Republic. The office of the President must remain a symbol of unity, stability, and national cohesion. This institution rises above political divides and speaks to the collective identity of the Mauritian people. I look forward to the Commission's work and to a thoughtful national debate on this very important issue. Madam Speaker, some voices and media narratives have attempted to attach the label of a second republic to the process of the possible introduction of an electoral college for the election of the president. The suggestion is clearly intended to instill fear. C'est le même refrain qui avait été utilisé en 2014 et c'est un acte de mauvaise foi. Allow me to be absolutely clear. This bill does not amend the Constitution. It establishes an independent commission to consult, examine, and recommend. Nothing more and nothing less. The final word remains with this august Assembly. Madam Speaker, when a constitution is comprehensively reviewed and modernized, it is entirely natural to speak of a new constitutional chapter. Ce n'est pas une rupture, c'est un renouveau, une renaissance. La France en est à sa 5e République. L'Inde a amendé sa constitution plus d'une centaine de fois. L'évolution constitutionnelle d'une nation n'est pas une menace. c'est un signe de maturité démocratique. Il y a une différence profonde entre les deux, et ceux qui les confondent délibérément le font pour effrayer plutôt que pour informer. Substantive reforms will be introduced and not cosmetic ones. Madam Speaker, on a separate note, I believe that the Constitutional Review Commission must also examine whether our framework adequately supports the protection of women, girls, children, and vulnerable persons, not merely in principle, but in practice. Formal equality, written in law, is necessary, but not sufficient. What is needed is substantive equality, constitutional space for the special measures that address structural weakness wherever it is. Madam Speaker, Mauritius is today the only country in the SADC region that has not signed the SADC Protocol on Gender and Development. This is not for want of commitment to the values enshrined in the protocol. Historically, concerns arose in relation to constitutional and legal rights provisions, particularly where the protocol contemplated measures going beyond the existing Mauritian constitutional framing of equality and non-discrimination. Earlier statutory impediments, including those linked to child marriage, Article 8 on marriage and family rights of the protocol, have since been addressed through legislative reform with the Children's Act 2020, repealing the Civil Code provisions on marriage below 18 years old. This matter is therefore no longer an issue for accession to the protocol. The remaining obstacles relate primarily to constitutional and legislative alignment, including the framing of equality and equity in the Constitution, family rights, access to economic opportunity, and women's representation in decision-making, amongst others. Madam Speaker, I understand that Mauritius did not sign the 2008 protocol because our principal concern lay with Part 2 on constitutional and legal rights, especially Article 5, which referred to affirmative action. This was considered not to be in line with the Mauritian constitutional framework, given Section 16 of the Constitution on non-discrimination. Following the regional review process, the 2016 revised protocol replaced the term affirmative action with special measures and introduced updated targets and additional provisions. The work of the Constitutional Review Commission, which is going to be set up with a bill, with the legislation, may provide precisely the framework needed to address these issues and to enable Mauritius to finally take its rightful place alongside every other SADC member state. That, Madam Speaker, is not a technical footnote. It is a matter of national dignity. These matters have already been flagged by the Ministry of Gender Equality and Family Welfare. Madam Speaker, the objects of the bill is to empower the President to appoint a Constitutional Review Commission to examine and make recommendations on constitutional reforms, including the protection of fundamental rights and the consolidation of democracy and institutions. I conclude by saying the following. The Commission will be independent. Every citizen willing to be heard, will be heard. Every institution, every political party, as well as the civil society, will have the opportunity to have their say in that commission. At the end of the day, it will be their constitution, the people's constitution. Madam Speaker, I therefore fully support the bill. I thank you.
Thank you. Yes, Honourable Prime Minister.
Yes, Madam Speaker. Madam Speaker, when I introduced the Constitutional Review Commission Bill, I said that constitutional reform cannot and should not be the monopoly of politicians alone. It concerns the entire nation. I'm glad, Madam Speaker, to see so many honourable members have taken part in the debate. In fact, I tried to count, there were no less than 28 interventions, honourable members, who participated in that vibrant debate. Let me then thank all of those who contributed to this debate. It is now time to take stock of what this House on both sides have had to say and to sum up what we can take away from these days of 3 days of deliberations. What we have learned, Madam Speaker, is this. The first thing is that on the essential question, the common ground is that after nearly 6 decades, the time has come for Mauritius to take a fresh look at our supreme law, our Constitution. There is an agreement on the need for constitutional reform. There are disagreements, of course, and they are real. However, they are not about the need for reforms, but they are rather about the scope of the reforms and the timeline of these reforms. Madam Speaker, I have listened to the range of voices that have spoken in favor of the principle. And from the opposition benches, the Honourable Opposition Chief Whip himself accepted that the question is not whether reform is necessary, but how it is to be done and the whole process. When the government and the opposition agree on the destination and differ only on the road, it is for us to take the road together as far as our political differences will allow. Because let us not forget, I say it again, that reform is for the country at large. Let me remind this House that what we are proposing forms part of the government program, 2025-2029, a bridge to the future. On the very first pages, this government undertook to appoint a Constitutional Review Commission to make recommendations on constitutional and electoral reforms. I emphasize on the word to make recommendations on electoral reform, constitutional reforms, and on the enhanced protection of fundamental rights. The program named various matters which are now before the House. One of them is the Electoral College to give the President a mandate from a broader base. Let me clarify a point that the Honourable Leader of the Opposition and also the former Deputy Prime Minister made. The remark that the amendment concerning the Electoral College for the election of the President was circulated on the very day the bill was being introduced. And the Leader of the Opposition asked whether it was an oubli. No, it was not an oubli. I'll tell you. There were queries that this might lead to all sorts of canvassing. We've seen how the MSM operates. Canvassing for personal gains, influence peddling, money exchange, all this we've seen. So there were some people who thought that this, including me, that this might be controversial. But all said and done, we decided that we should allow this point to be debated and examined by the Commission. And the whole point is that the Commission look at all the proposals. It was in our manifesto. in our government program of 2025-2029. So therefore, it was decided at cabinet level that it is better to have the debate and let the Commission examine it. Madam Speaker, the Attorney General has explained very clearly what an electoral college is. He made reference to the republics of Trinidad and Tobago, and great democracies like India and Germany, how they use it to choose a head of state who belongs to the whole nation, not to the governing party of the day. I will not repeat the comparison, Madam Speaker, but I should address the insinuation that this conceals some personal ambition. The Deputy Prime Minister has just made reference to it. I don't know what kind of fertile imagination people might have. Instead of looking at the text, they become hysterical. That insinuation does not deserve the dignity of a response, Madam Speaker. The terms of reference make no mention of the powers of the President of the Republic having to be looked into. None, whatever. The office of the President of the Republic will remain what the office has always been. That is, a guardian of the Constitution and a symbol of our unity, while the executive answers as it must to this elected House. That is all. The bill also goes on to introduce mandatory holding of local elections, which were postponed. Honorable Ramphal made reference to it, Honorable Ajay Devi made reference to it, I think Honorable Bhagwan also made reference, Ajay Ganesh made reference to it, Honorable Bhagwan made reference to it. They were postponed 3 times, Madam Speaker. The bill also introduces the protection of new generation rights, environmental, technology, health, education, and the rights of nature, and the enshrinement of the values of peace, justice, and liberty that we pledge in our national anthem. It promised to consolidate the constitutional right to privacy and to outlaw the mass covert surveillance of citizens. As Honorable Ramphal said, people seem to have short memories. He referred to the IBA Act, if I'm not mistaken. But the MSM regime also tried to control what people were saying on social media, the internet and everything. And there were protests across the country, especially the young were protesting. And what did they do? They withdrew their propositions. You would think it's a laudable action that they did. No, Madam Speaker. What they did behind the back of the people, what they did, in fact, surreptitiously, did it without going through Parliament. Behind our back. This was done. Massive surveillance of all the people of this country. I said it before. The bill also promises to reinforce the independence and the role of the Director of Public Prosecutions, who will now be the ultimate person to decide whether to prosecute or not to prosecute. We have already extended put the powers of the DPP, as the Constitution says, but the DPP will now have exclusive prosecutorial authority. No one else can decide whether to prosecute or not to prosecute, as it should be. As the previous regime tried to change, I think Honorable Bulel made reference to that, how they did it. This government, Madam Speaker, stands by its promises, whatever may be said. The demand for constitutional reforms did not originate from a meeting in cabinet. This is not the agenda of a political party that honorable members are being asked to support. It is the agenda of the nation. This bill is nothing more and nothing less than the continuation of our solemn undertaking in November 2024, and we got a mandate for it. Madam Speaker, the opposition has pressed essentially three concerns, and let me address them in turn. One of the sequence of events, the complaint that persons were designated before the law was passed. Honorable Utim, Minister Utim, addressed that concern. The Attorney General has set out the constitutional position under Section 64. Madam Speaker, we sought the counsel of the former Chief Justice and a former Director of Public Prosecutions on the very shape of this bill, because we wanted it to be better, not because we wanted to bind anyone's hands. We haven't done so. On the fear of delay, the warning that this should become a vehicle for delay, as recommendations of the past commissions have been cited. I sit with the Honourable Chief Whip, Honourable Juval.
No, the Honourable Whip of the Opposition.
Whip of the Opposition, sorry, again. I take the warning seriously. The Honourable former Deputy Prime Minister also spoke about this problem of delay. But I ask the House to take note of the proposed remedy of the Honourable Chief Whip, Opposition Whip. He says we should do an interim report on the simpler reforms, followed by a full report. It is not an argument against this bill. It is not. And besides, what we want to do, exactly what the former Deputy Prime Minister is saying, we want to avoid delay. We don't want to create delay. We don't want to have ever-ending debates. On a lot of things already we have spoken. On the independence of the Commission, the charge is that we will impose an agenda through the list in Section 4. Madam Speaker, I will simply say this. As I said, Honourable Tim clarified the issue very well. He explained the constitutional role of the President and the role of Cabinet. The House will appreciate that the terms of reference are far-reaching and deal with fundamental democratic and human rights issues. Madam Speaker, I wish to acknowledge the speeches from the opposition were in substance, from what I understand, in favor of the ambition of this reform for the rights of nature, for social and economic rights, for the citizens' privacy, the transparency, for honest reckoning with the place of women and the vulnerable in our republic. Honourable Subon has many times spoken of the rights of nature that need to be protected. I may add that rights go together with duties. We should not forget that either. May I also respond to what Honourable Joanna Béranger said? Why, good question, why the electoral system, electoral reform is not part of the remit of the bill? I must say, and quite rightly, the former Deputy Prime Minister pointed out that electoral reform should be a separate, done separately. We agreed with it, I agreed with it as well. Because the danger is you reopen a debate that has already taken place and it will be never ending. We already had large consultations, and again we've had, on this matter. In any case, electoral reform too will have to be debated in this House at the end of the day. And let me assure our friend from Rodrigues, Rodrigues is not going to be forgotten, will be part of that reform. Madam Speaker, as I emphasize, the case for reviewing the Constitution does not belong to the government. It does not belong to the opposition either. It belongs to the whole Republic. Some, both in this House and outside, have argued that this whole enterprise is going to be eyewash. Commission appointed, as some cynics are saying, they will bury the very thing it pretends to examine. I think the Attorney General spoke about this, about the architecture of the bill. No government that wishes to bury constitutional reform invites, as we are doing now, the entire nation to delve, to debate, to discuss the process and the future content. As the Attorney General rightly pointed out, one does not bury a problem by holding public sittings. And public sittings across the country, by inviting every citizen, every party, every union, every NGO to put their case on record, by undertaking to bring back the results to this House in the full glare of debate. We're not going to hide it. But the cynic's danger is real. Let's not shy away from it. But the cynic's remedy to stand aside, not to participate, as some have done, on electoral reforms. I invite every member of this House and every Mauritian to do exactly what has to be done, that is, to be an actor, to participate in that debate. Madam Speaker, I opened the debate by saying that a constitution alone does not save a democracy. What saves it is the strength of its institutions and the vigilance of its citizens, as Honorable Minister Jitan rightly pointed out. This debate and the wider debate, now alive in the press and among the public, has been an exercise in exactly that vigilance, and we are better for it. Independent, strong institutions are the litmus test of a democracy. As Honorable Jitan rightly said, we are not rewriting history, but we are preparing for the future. We are building the bridge to the future, Madam Speaker. At the time of our independence, Sir Shiv Sagar told this nation that we had chosen the democratic way of life to be guided by fair play, by justice, and the rule of law. We are, as Honorable Junior Minister Narsinghen said, we are a liberal democracy. The Constitution of 1968 has served us well. Honorable Rampal is right. It wasn't imposed totally on us. There were wide debates, discussions. But it has served us well, that Constitution. But it has also, over time, nearly 6 decades now, it has exposed vulnerabilities over time that we cannot and should not ignore. As I said when introducing the bill, a constitution cannot remain frozen in time while society is evolving. Some people are saying you shouldn't touch the constitution at all. It's wrong. A constitution is a living instrument. It must be adapted to the realities of today. I like the reference Minister Jitan said on the compass on a ship. You know the direction, it shows the way, but you must adapt to the changing conditions when you are at sea. Madam Speaker, we want to reopen the debate on electoral reform. As I said, this has already been done. Although I must add, and I did say that in my introduction, there are certain matters that the Commission will examine. For example, to strengthen the powers of the Electoral Commissioner and the Electoral Supervisory Commission. The Commission will have to examine the package of reforms. They can make comments. The Electoral Commissioner and the ESC, for example, they have made comments. I've circulated this in Cabinet. We didn't see it that way, but there are unintended consequences sometimes about the non-declaration of your community. They pointed this out. This is why this cannot stand alone. We have to have the whole package of electoral reform to make it. Otherwise, what Honorable Shakil Mohammed said, he mentioned this. Just the one bit alone doesn't stand. It has to be the whole. The government, and we intend to do it. This government, Madam Speaker, has kept the promise it made to establish the Commission. Je dirais, Madame la Présidente, le projet de loi traduit directement un engagement pris dans le programme gouvernemental 2024-2029. Le projet de loi institue une commission indépendante chargée de revoir notre loi suprême, notre Constitution, de proposer des réformes majeures qui devront être votées ici. Mais moi, je l'espère. I can understand the worries of the former Deputy Prime Minister. That may go on for ages, 2 years, 3 years, 4 years, or whatever, and you have another election. Moi, je l'espère, Madame la Présidente, qu'avant que nous célébrons le 60e anniversaire de notre indépendance, la réforme sera là. It now falls to this House to let the Commission do its work. It now falls to the nation to make its voice heard within it. We have to move forward, Madam Speaker, with the reforms. It is a defining moment in our history. With these words, Madam Speaker, I commend the bill to the House.
It has to be seconded. In fact, you commend the bill and it has to be seconded, yes? Deputy Prime Minister. Question is that the Constitutional Review Commission Bill, number 6 of 2026, be read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
Committee stage. Clause 1, short title. Clause 2, interpretation. Clause 3, Constitutional Review Commission.
The question is that clauses 1 to 3 stand part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Clause 4, functions and powers of Commission.
The question, I'm sorry? It has been amended.
Madam Speaker, I move that Clause 4 be amended as per the amendment circulated.
Okay. The question is that Clause 4 be amended as per amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. The question is that Clause 4, as amended, stand parts of the bill. That those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 5, rules of Commission. Clause 6, public access to proceedings. Clause 7, proceedings of Commission. Clause 8, duty to cooperate. Clause 9, deposit of records. Clause 10, replacement of commissioners. Clause 11, secretary to commission. Clause 12, qualified research assistants, consultants and experts. Clause 13, administrative assistants. Clause 14, confidentiality of proceedings and information. Clause 15, immunity from suit. Clause 16, remuneration and expenses. Clause 17, commencement.
The question is that clauses 5 to 17 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. The question is that I do report to the House that the Constitutional Review Commission Bill, number 6 of 2026, has passed the committee stage with amendment. Those in favour say aye. Aye. Those against say no. The ayes have it. You may resume your seats. Honourable members, I have to report to the House that the Constitutional Review Commission Bill number 6 of 2026 has passed the committee stage with amendment.
Verdict bills, third reading.
Speaker, I move that the Constitutional Review Commission Bill number 6 of 2026 be read the third time and passed.
And somebody is seconding? Yes. The motion is seconded. This question is that the Constitutional Review Commission Bill number 6 of 2026 be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Prime Minister, adjournment.
Yes, Madam Speaker, I move for the adjournment of the House to the 19th of June 2026 at 5 p.m.
Okay, the question is that the House be adjourned to the 19th of June at 5 p.m. 5 p.m. Okay, those in favour say aye. Aye. Those against say no. The ayes have it. The House stands adjourned.